Court will note the appearance of Ms. Reed on behalf of the plaintiff, Ms. Thomas on behalf of the defendant. The matter is before the court on the defendant's motion for temporary custody, parenting time support, exclusive use. I do note that the plaintiff has filed a response, and I've reviewed all of those. Anything else to add, Ms. Thomas?
I do, Your Honor. I was quite surprised from the response. I've never seen a party so blatantly attempt to get hearsay information before the court as has been presented in this matter. I will first ask the court to strike all attachments to plaintiff's answer to defendant's motion as hearsay, which in some cases were specifically prepared for this very motion. Counsel should be frankly ashamed and should be admonished accordingly. That's crazy. I would ask the court, first of all, to note that plaintiff's complaint for divorce at number 10, wherein plaintiff clearly states, and I quote, "It is in the best interest of the minor children for the parties to share joint legal custody and joint physical custody with an equal parenting time schedule." First, we note that there are minor children, not a minor child. And secondly, plaintiff specifically requests joint custody and equal parenting time. In defendant's answer to complaint at number 10, he recites his concerns regarding plaintiff's drinking and his reasons for believing that plaintiff's request is inappropriate, and asks this court to grant relief, which is in the minor child's best interest, not indicating whether it was custody for him or her or whatever, just what's in the children's best and safest interest. Subsequently, based upon happenings, we filed two motions, one regarding financial matters that although 10 days ago, we believe we had an agreement on that, and I believe we still do. We've not seen a signed order yet. The other motion was, in fact, the present motion regarding custody, parenting time, child support, exclusive use on a temporary basis. In our motion, we've identified the defendant, his concerns regarding the care of the minor child based upon plaintiff's use and abuse of alcohol. Of course, unlike plaintiff, we did not attach our eventual exhibits, including photos and copies of posts wherein plaintiff acknowledges her drinking issues to said motion, as it's inappropriate to do so. However, we clearly quoted plaintiff's own words where she has, in fact, acknowledged her drinking issues. The immediate response from plaintiff was to file an amended complaint for divorce, wherein the only change from her initial complaint was paragraph 10 and the correlating request for relief, wherein she now requests sole legal, sole physical for herself and reasonable parenting time for defendant, indicating that it is in the best interest of the minor children for the plaintiff to be awarded sole legal and sole physical custody of the minor children, with defendant having reasonable parenting time. Said amended complaint was clearly filed in retaliation of defendant's present motion and for request for plaintiff to receive help for her alcohol addiction, and wherein he requested temporary custody until there's a positive movement for the plaintiff receiving the help that she needs. Parenting time as in the children's best interest, with restrictions as necessary just to keep them safe. Court monitored alcohol assessment and treatment, and a child support based upon the Michigan child support formula. Between her first complaint and her amended complaint, plaintiff offered no facts or change in circumstances in the intervening 50 days since the filing of her complaint for divorce, although defendant received defendant's response to her amended complaint on May 8th and has had defendant's motion since May 6th. She failed to file an answer timely, filed her hearsay evidence attached to her answer on Friday afternoon, not allowing us time to do any kind of a reply. We know that we were trying to work together and work something out, but still, that was still kind of attack by surprise, when in fact that's not what had been claimed in the first time around. We believe that plaintiff's outlandish allegations, which appear to be from her anger with defendant for bringing up her alcohol addiction at all, the creation of documents to support her answer questions not only her veracity of the signer, but the ethics of all those acting in conjunction with the plaintiff. Step one of alcohol reliance is admitting there is a problem, and although plaintiff wrote it down, she will not admit in public she has any issues, which is sad, and she's not going to get the help she needs until she's admitted that. Defendant doesn't believe that plaintiff's a bad mom. He believes unless she gets an assessment and treatment for her use of alcohol, she will continue to put the kids at risk, as she has acknowledged in her own words, in her own writing, that she's done in the past. I believe it should be clear to the court that under these circumstances and with recent police involvement, these parties cannot peacefully reside together, and plaintiff has repeatedly stated her intent to move out. In fact, her plan was to move last Friday, but then she got mad at defendant and it had chosen not to leave. Then I I thought she was partially moved, but I'm not, I know that that was the agreement of the parties. And so we're asking that the court award defendant exclusive use of the marital home and require the plaintiff to move forthwith. Without random monitoring, defendant believes that plaintiff will continue to play the system as she has through testing her breast milk prior to nursing to make sure there's no alcohol in it, although she claims she knows after 3 hours there will not be. And so no one would have cause to contact CPS. Through hiding her issues and orchestrating her co-workers not to tell, defendant is prepared to testify as to all the allegations are truthful, and the ones with quotation marks are absolutely actual written words by the plaintiff, meaning she knows she has a problem, simply will not admit she needs help in detriment to her own children. In attempting to work something out with plaintiff to get help, defendant had offered a forensic assessment and evaluation with Dr. Haugen with treatment as he sees fit, and was prepared to have Dr. Haugen even review the defendant's suggested use of SoberLink as the first step to a solution. Defendant was also willing to defer plaintiff paying him child support until the beginning of next year for the sole purpose of helping with the costs related to SoberLink. With random testing and whatever criteria this court may believe is in the best interest of the children regarding any missed tests and or positive results, should define the parenting plan on a temporary basis. And of course, defendant defers to the court and your expertise with regard to that. Mr. Martin simply wants his children to be safe. And until there's help, until there's an assessment, until there's, we're asking a forensic assessment because that's the only way that the entire story is going to get to Dr. Haugen. One quick mention that we will say, for example, with the attachments and all this, is that the photo that plaintiff decries is from the same day as the day she filed for divorce is incredulous to me, as she filed for divorce on March 18th, 2024. And that particular photo was posted on Facebook on February 4th, 2024. So more than a month beforehand. So unless there's magic clairvoyance or something, it's just a continuing ongoing lack of veracity. We're asking that this court keep these children safe, grant Mr. Martin the exclusive use of the home, him on a temporary basis have custody, and then have Dr. Haugen involved. We're more than happy to share with Dr. Haugen what we believe the SoberLink, the two-step plan should be. And if he thinks that's excessive, that's fine. But we want to make sure the kids are safe when they're in mom's care. We think she's a good mom when she's not drinking, but that's not what's been happening, and we have to make sure they're safe. So we're asking the court order accordingly.
Okay, Ms. Reed.
Your Honor, my client denies all allegations of alcohol abuse or substance abuse. She is currently seeing a counselor to deal with defendant's emotional, physical, and mental abuse that he has escalated since he's been served with the complaint for divorce. We did amend that complaint as he escalated his abuse since he was served to so legal and so physical, as it's abundantly clear that the parties can't co-parent and can't communicate well, as evidenced by the defendant's example in his motion of my client simply creating a bubble machine for Roman to play with. He manipulated it and turned it into some sort of incident of child abuse and neglect, that my client was putting this child at severe risk of harm. They were putting together a bubble machine to play with. This is ridiculous. My client would agree to doing a substance abuse evaluation with Dr. Haugen to disprove the defendant's outrageous claims that she's drunk all the time. Her employer has never reported she has a spectacular work history. Her coworkers will testify that they have never seen her drunk at work or drinking at work. The doctor for the children will testify that my client is providing and scheduling the child's care with the doctor's offices, provides soothing and comfort for the children when they're upset at the doctor's office, and she's a fantastic mom. We find it very interesting that he claims that my client's providing an unstable environment or a dangerous environment and is at risk of putting these children in danger when she's been the parent that provides care, comfort, clothing, feeding the children, doing everything for these children. She's the parent that gets up at night and soothes London and feeds London while the defendant is sleeping, and he sleeps through her cries. She's breastfed Roman until he was the appropriate age to stop. She's continuing to breastfeed London, and the defendant doesn't have any problems with her breastfeeding these children, yet he's claiming that she's drunk 24/7, which does not make sense. He's also
Okay.
claiming that she is unstable and unsafe, yet over the weekend, when she moved out last week, she had the children in her custody. So we're
Okay.
denying all of those
Okay.
allegations and
Ms.
asking
Reed,
that my court.
I don't need anything more. What I'm gonna do is, in this case, obviously, we are diametrically opposed to testimony, if you would, if offering that, or positions in this case. So the court's gonna need at least some evidentiary hearing in this matter. What the court is gonna do is, I'm gonna schedule this for a limited scope evidentiary hearing on June 5th. It's a Wednesday, June 5th at 2:00 p.m. I'm going to allow each of the parties to have 1 hour to present their case through obviously their own testimony or others, but they'll have 1 hour each, and that's taking into consideration direct and cross-examination, and the court will reserve and make a decision at that time on the motion in this case. So we will see you all back on June 5th, and we'll get it all taken care of at that time.
Judge, can I ask a couple questions? So at that hearing, can we bring witnesses should we so desire?
You have 1 hour. So
Okay, so
if
use
you,
any way I want to.
if you bring witnesses and don't have your
Okay.
client, you're taking up your hour that way. That's
Nope, that's fine. Okay.
Okay.
And
so
then,
each party will have 1 hour, and that's including, I'll keep track of cross-examination and examination. So
okay,
obviously use your hour the way you want.
nope, that's fine. And
Okay.
then it sounds like that, I guess a couple other things, and I didn't mention that Ms. Reed did not either. I believe both of us agree to communication should be through our family wizard. If that's the case, I would like to get that started before then even.
Ms. Reed,
If Ms.
is that agreeable?
Yes.
That's fine. Why don't you put
And-
that in the order? Ms. Thomas, you also, plaintiff has stated she'll do an assessment with Haugen, so you can put that in as well.
Is this court fine with it being a forensic assessment?
Ms. Reed,
I don't have an issue with that, but we're also requesting that the defendant undergo one as well.
Ms. Thomas, you have any problem with being mutual?
I do not.
Okay,
No.
go ahead, put that in the order.
Okay, and then it sounded like Ms. Reed said that Ms. Martin had moved out. Is that I just want to make sure what that situation is too.
Friday. She moved out Friday.
Okay,
So at this point, exclusive use to Mr.
you can give him exclusive use because she obviously claims she's out of the house.
Okay. All right, great. Thank you.
Okay, we'll see you back on June 5th. Have a good
Great,
day.
thank you.
This is the Craig versus Edie case,
Okay,
calling case 2021-1298 DS. Deshaunette Craig versus Ledero Edie. Today is Monday, May 20th, 2024 at 9:31 a.m.
court will note the appearance of Ms. Reed on behalf of the defendant. This matter is before the court on the defendant's motion for parenting time and for modification of support. Ms. Reed.
Thank you, Your Honor. We're here to get my client a parenting time schedule because the order that was entered in 2021 just says parenting time as the parties agree. And the plaintiff has interpreted that as no parenting time, and he hasn't seen his children in quite a while. So we're wanting an enforceable, reasonable parenting time schedule, and then child support modified accordingly.
Okay. Ms. Craig, what's your response?
He can take his child support, but I mean, my kids don't. We've been through. He's not seeing my kids.
He's what?
He's not seeing my kids, but he can get his support.
Okay, well, what he's claiming is he says, I want to see my kids, is what he's saying.
Okay, but my daughter just now became back being a kid. We went through something with him where my daughter was scared to use the bathroom. My daughter was scared to take baths. My daughter I do not allow him to see my kids. And I do it for the safety of my kids. I feel like I tried to reach out for help. I got no help. So I took it into my own hands. He can take his support, but no, sir, I'm not going to let him see my kids.
Well, ma'am, if I order him to see the kids, he will see the kids, or you will go to jail. So we'll get that matter straight right now. Did you contact DHHS when you said you had some issues?
He contacted them as well. He's contacted them on me a lot.
Okay, so DHHS has been involved previously.
Mhm.
Well, what the court will do is order that within 14 days of today's date, that the parties will exchange their paycheck stubs or the 2023 tax returns if they filed. And then Ms. Reed can take that and calculate the support based upon what that amount is. Ms. Reed, obviously she's brought up some issues, the kids not wanting to go. Is there some utility to having a counselor involved to make a recommendation?
It might be helpful. I don't know how busy Margaret Hunter and Meredith Katz is right now, but regarding CPS, we requested the entire CPS file for this party, and the last issues were, I believe, in 2021, and I don't think anything was substantiated.
Okay, well, why don't we do that? We'll let you get that. Court will send the matter to either Meredith Katz or Margaret Hunter, whoever they can get the kids into first, and order that the parties would cooperate and have the appointment scheduled. Why don't we try Miss Katz first? I know Miss Hunter, I just had her on something. She was pretty busy, but let's do it with Miss Katz first. And if can't get into Miss Katz, then we'll do Miss Hunter, and I'll order that the parties would communicate with Meredith Katz office within 30 days of today's date to set up an appointment for the children to, again, to talk with her. And then she can give us a recommendation as it relates to parenting time.
And is it going to be parenting time at the recommendation of Ms. Katz, or are we renewing a motion once we have the recommendation?
Once we have the recommendation, I just say the court will consider her recommendation, but I never defer to the counselors on those. So what we'll do is simply have her do a report in that, and then we will have a short hearing if we need to at that particular time. The court will order that, again, that the parties would pay 1/2 the cost of the counseling. Anything else, Ms. Reed?
No, Your Honor.
Ms. Craig, anything else?
No.
Okay, thank you. That will be the order of the court. You can submit that under 7 days.
Thank you.
Have a good day.